Start. To justify the judiciary's power of directing the CBI to investigate offences in other states without its consent, the court ended up pitting one basic feature of the constitution (judicial review) against two others (federal structure and separation of powers) put forward by the petitioner. However, the question of the violation of basic structure of the constitution does not even come into the picture in this case, as the basic structure doctrine is used only when a challenge has been made to a constitutional amendment. This case does not deal with any constitutional amendment, but with the action of the judiciary itself. Extending the basic structure doctrine to judicial actions is taking it far beyond the limits within which it was intended to apply. To complicate matters further, the court concluded that any law that abrogates or abridges fundamental rights would be violative of the basic structure doctrine. Quotation close. This can have two far-reaching implications: first, that the fundamental rights are part of the basic structure, and second, that even ordinary legislations are now subject to the basic structure doctrine. The applicability of basic structure doctrine to ordinary legislation has been debated before. In Indira Gandhi versus Raj Narayan, the majority, refuting the contrary arguments of Begje, held that the Constitution already imposes restrictions on ordinary lawmaking power, and to subject such statutes to basic structure would mean rewriting the Constitution and robbing the legislature of acting within the constitutional framework. This view was accepted in later cases. Para. The court has unreasonably expanded the scope of the basic structure doctrine by bringing within its ambit legislative and judicial actions without even examining these earlier decisions or discussing the implications of such an expansion. Any further expansion of the doctrine by including even executive actions within its purview would virtually replace or equate the fundamental rights with the basic structure doctrine, subjecting any state action, legislative, executive, or judicial, to the basic structure. Para. Article 226 gives High Courts the power to issue directions, orders, or rights for the enforcement of fundamental rights and for any other purpose. In the present case, the court expanded the scope of Article 21 and held that Article 21 protects not only the rights of an accused but also the rights of the victim. The state has a duty to enforce the human rights of a citizen, providing for fair and impartial investigation against any person accused of commission of a cognizable offence. Quotation close. In certain situations, even a witness to the crime may seek such protection. This is a significant step in the jurisprudence of Article 21 in relation to criminal law, which till now has focused much more on the rights of the accused than of the victim. Hence, the judgment implies that if the right of a victim to a fair and impartial investigation is being violated, the High Court can issue directions to the CBI by exercising powers of judicial review under Article 226. What needs to be examined is whether this power gets whittled down by any of the arguments put forth by the petitioner in relation to the federal setup and separation of powers. Instead of examining these arguments under the basic structure doctrine, it needs to be seen whether any such restriction has been provided by the Constitution on the High Court's power of judicial review. Para. The petitioner argued that if the Parliament passes a law authorizing the police of one state to investigate in another without its consent, such law would be invalid. Hence, even the judiciary, being subservient to the Constitution, cannot pass any such direction disturbing the federal setup provided under the Constitution. In the context of the federal setup, the court concluded that since the judiciary itself is the protector of the federal structure of the Constitution, a direction under Article 226 to uphold the Constitution cannot be termed as violating the federal structure. Para. The court has not adequately analyzed the power of the High Courts under Article 226 While the petitioner is correct in asserting that such a law, if passed by the Parliament, would be invalid, it needs to be understood that this illegality is not because of violation of a basic feature, but because the Parliament lacks legislative competency to enact such a law as per Article 246. The issue has to be examined within the framework of the Constitution, which itself provides for the federal setup. It provides for distribution of legislative and executive powers between the center and the states, but it provides for an integrated judiciary wherein both the High Courts and the Supreme Court interpret state and union laws, having jurisdiction and providing remedies in all constitutional law cases. With the insertion of clause within bracket 2 in Article 226, a High Court within the territorial jurisdiction of which the cause of action arises can issue directions to any government or authority situated even beyond its territorial jurisdiction. Hence, where an explicit restriction has been placed on the Parliament's powers under Article 246 read with 7th schedule, and in the absence of any such restriction over the powers of the High Court, the analogy drawn by the petitioner is flawed. It is by reason of such a constitutional setup that the High Court's direction under Article 226 is valid, and not merely because the judiciary itself is the protector of the federal setup as held by the court. Stop.